I call Ian Lees-Galloway.
Thank you very much, Mr Chairman. Pleasure to rise and speak on part 2 of the Construction Contracts Amendment Bill, a part which appears to be significantly amended by the Minister's Supplementary Order Paper number 106. Can I say at the outset that on this side of the House we acknowledge the interest and enthusiasm in the issues addressed by the Supplementary Order Paper from the Minister. I understand from speaking with colleagues who were on the Select Committee that the interest in this issue of retentions, this issue of trying to not ensure, not give a cast iron guarantee, but to provide more security of payment to small business people, to tradespeople in particular, is something which this Minister has picked up, and that enthusiasm was absent before the Minister took over the role. So I want to acknowledge that the Minister has decided to pick this up, and that's probably why it's been a long time between drinks as far as this legislation's progress through the House has been concerned, as the Minister has been working on the Supplementary Order Paper with officials. So we appreciate that that's taken some time. I agree, though, with Ria Bond that time is money, and we're talking about people who they're not big business people, they're not people with large accounts, they're people who are they're going from one contract to the next, and money in, money out for most people. And so the fact that this has been something which has taken the Parliament and the Government considerable time to reach this point on is, will have been concerning and devastating for a lot of people who were affected by some of those high-profile collapses, and other people who haven't had their stories told in the media, who have had to face the issue of not being able to recover payments from principal contractors. These changes are significant, though, and it's a shame that the changes have not been to Select Committee. The Minister hasn't assured us that he has consulted. We don't know exactly the scope and the and with whom that consultation has been carried out, but it would be, I think with this level of amendment to the legislation, we're almost in part 2 here dealing with an entirely different piece of legislation than what the Select Committee considered. So it's a shame that it hasn't had a chance to go back to the Select Committee. So I want to look at subpart 2A, which relates to the retention money. And this sets out in quite some detail how retention money is to be dealt with, and how it's parties have to put that money into trust, and what they can and cannot do with that money. One bit that was of interest to me, and I would appreciate the Minister taking a call on this, is 18F under subpart 2A, the investment of retention money. Now this may be something which has been addressed, but 18F 1 says retention may be invested by Party A in accordance with the Trustee Act 1956. Now I've got to be honest, I don't know what limitations the Trustee Act 1956 places on the types of investment that money can be used for, but then 18F 2A concerns me a little bit, because it says that if upon the realisation of any investment the amount received is less than the amount invested, Party A must make up the difference between the amount invested and the amount released. So in other words, it envisages the possibility that Party A could invest that money into something which actually leads to a loss, and some of that retention money is lost as a result of that. Now, of course, in the legislation, there is an expectation that that loss would be made up when any payment to Party B had to be made. But in the event that Party A meets some unfortunate circumstances, Mr Chairman.
Ian Lees-Galloway.
In the event that Party A does meet some unfortunate circumstances and is in a position, finds it difficult to make its payments to Party B, which is exactly the type of situation that we're envisaging here. It's exactly the reason why money should be set aside in trust so that there is some more security around those payments to Party B. If Party A finds themselves in financial difficulty, they may have some trouble making up that difference between what they actually put in trust and what they're able to recover from it if there is a loss as a result of investing that money. So I would appreciate some clarification from the Minister exactly what restrictions and limitations are placed upon the types of investment that money can be used for. Because if there are no limitations, and as I said, I don't know what the Trustee Act 1956 says about this, but if there are no limitations, then there is the potential there for that money to be invested in something which is high risk and could result in exactly the opposite to what this legislation, what this part of the legislation seeks to achieve, which is to have money put aside securely so that it is available for payments to be made. So I would appreciate some advice on that from the Minister or any member opposite who has some knowledge about how that is potentially going to work, because the other clauses under 18 do appear to be all about protecting the money. There's interest on late payments that's to be expected under any contracts. Protection of retention money under 18H, which says retention money is not available for the payments of debts of any creditor of Party A other than Party B, is not liable to be attached or taken in execution under the order or process of any court. The money can't just be used. 18E talks about the use of retention money. It cannot be used for any other. It cannot be used other than to remedy any defects in the performance of Party B's obligations under the contract. So the purpose of that money is quite clear in the other parts of this particular subpart 2A. But I just wonder whether that ability to invest that money is really in line with those.
Sorry to interrupt the honourable member. The time has come for me to report progress. Thanks, Nick.
Members, the House is resumed.
Mr Speaker, the committee has considered the Accident Compensation Financial Responsibility and Transparency Amendment Bill and reports it without amendment. The committee has considered the Passports Amendment Bill number 2 and reports it with amendment. The committee has considered the Tariff Free Trade Agreement between New Zealand and the Republic of Korea Amendment Bill and reports it without amendment. The committee has considered the Construction Contracts Amendment Bill and reports progress. Mr Speaker, I move that the report be adopted.
The question is that the report be adopted. Those of that opinion will say aye. And to the contrary, no. The ayes have it. The Accident Compensation Financial Responsibility and Transparency Amendment Bill, the Passports Amendment Bill number 2, and the Tariff Free Trade Agreement between New Zealand and the Republic of Korea Amendment Bill are set down for third reading next sitting day. The Construction Contracts Amendment Bill is set down for further consideration in committee next sitting day. The House stands adjourned until 2 p.m. tomorrow. Nō reira, tēnā koutou, nā mihi nui a koutou, tēnā koutou katoa.